The Attorney General's office states that you overpaid child support by $13,476.88. And after your son graduated high school, did you continue to receive those child support payments?
I did.
Have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
What are the reasons why you didn't return the money?
Emotional, physical needs. I mean, he was never there for my child. It's more to take raising a child than finance.
So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
All right, you're both officially under oath. I'm gonna go ahead and let Mr. Starr call you both as witnesses. The state will have the opportunity to cross-examine. And again, at the end of the hearing, ma'am, if you have anything else you think I need to know that didn't come out during your general testimony because you're a pro se litigant, I will allow you to testify to it in a narrative form, so long as it's relevant. So at this time, Mr. Starr, you can call your first witness, please. Thank you.
I'd like to call my client, Mr. Guy, please.
Yes, sir.
Okay,
All right,
Mr.
Mr.
Guy.
Guy, state your full name for the record, sir.
Stanley Allen Guy.
All right, you may proceed.
All right, and Mr. Guy, will you state your son's name in this case?
LeZabrion DeJour Williams.
Okay, and did he turn 18 years of age on December 13th, 2020?
Yes, he did.
And did he graduate high school in May of 2021?
Yes, sir.
And to your knowledge, since your son graduated high school, have you continued to have your wages garnished for the purposes of child support?
Yes.
Okay, and was the last child support payment you made, did that occur in September of 2022?
Yes.
Okay. Now, do you remember uploading to our case management software a document called a financial activity report that you received from the Attorney General's office?
Yes, sir.
All right, to your knowledge, did you alter that document in any way?
Not at all, sir.
Okay. Your Honor, I'd like to submit that document into evidence. I emailed it to you and I believe the Attorney General, but they should have it as well.
You emailed it to Belinda?
Yes,
All right, guys, buckle up. This courtroom drama kicks off instantly with a financial bombshell. A father claims he overpaid more than $13,000 in child support even after his son graduated. And shockingly, the mother admits she never returned the money. Instead of denying it, she leans on emotional reasoning, saying he wasn't present in the child's life. The judge sets the tone quickly. This isn't about feelings. It's about facts and law.
Yes, I did.
All right.
State has no objection, Your Honor.
Okay, I must have left it on the bench. Can you go grab it for me, please? Yeah, I'm sorry. I had to move off of the bench and move over here. So
There's also
here it is. It was underneath.
okay. There's also the state disbursement record. We're going to just enter that into the evidence as well. It should
I've got it here.
confirm.
Just
Okay.
a second here. All right, here we go. And so I'm remarking this is respondent father's number one. All right, folks, I know you can't see it very well, but this is the respondent father's number one. It is the accounting of the child support that was paid to the state disbursement unit in this case. Is there any reason this should not come into evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, is there a legal reason this shouldn't come into evidence, ma'am?
No, Your Honor.
All right, respondent father's one is admitted. You may proceed.
All right, Mr. Guy, did you see at the end of that document, the Attorney General's office states that you overpaid child support by $13,476.88?
Yes, sir.
Does that amount seem accurate to you?
Yes, sir.
Okay. Do you also remember submitting to our office a document titled Texas Child Support Disbursement Unit Payment Record?
Yes, sir.
Okay, and to your knowledge and belief, was that document altered in any way?
Not at all, sir.
And do you believe the information on that document is correct as well?
Yes, sir.
All right, I'd like to submit that as Petitioner's Exhibit 2, Your Honor.
All right, I'm marking this as respondent father's RF2.
All right, Mr.
All right.
Go ahead.
Any objection to RF2 coming in evidence at this time, Mr. Diamond?
No, Your Honor.
All right. Ms. Williams, is there a legal reason that this information should not come before the court this time?
No, sir.
All right. RF2 is admitted. You may proceed, Mr. Starr.
Okay. Since your son graduated high school, Mr. Guy, has Ms. Williams paid you back any of the overage amount of child support?
No, sir.
Okay, would you like the court to award you a judgment, $13,476.88, to make up for the excess amount of child support that has been garnished from your check?
Yes, sir.
All right, and would you like the court to award you attorney's fees since you had to hire me to get this money back?
Yes, sir.
Is there anything else you think the court should hear today, Mr. Guy?
No, sir.
I have no further questions with this witness.
All right, Mr. Diamond.
No questions, Your Honor.
All right, at this time, Ms. Williams, technically you're your own lawyer. I always make have pro se litigants, if they have questions, they have to run them through me because I want to make sure that they're relevant. So at this time, ma'am, as your own legal representative, do you have any questions, Mr. Guy?
No, I don't have any questions, sir, but I do have a statement.
All right, well, that's at the very end, ma'am. Thank you.
Okay.
All right. So, Mr. Starr, you can call your next witness, please.
All right, I'll call Ms. Williams, please.
All right, Ms. Williams, state your full name for the record.
Bertina Levette Williams.
All right, thank you, Ms.
Mr.
Williams.
Starr.
Okay. How old is your son now, Ms. Williams?
He's 20 years old.
All right, and when did he turn 18?
He turned 18 and I think it was 2020 of December 13th.
Okay. And did he graduate high school of May of 2021?
Yes, he did.
Okay. Now from September 17th, or excuse me, from September 7th, 2011 to September 27th, 2022, did you receive child support payments for your son?
I did, sir.
Okay. And after your son graduated high school, did you continue to receive those child support payments?
I did.
All right. Have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
No further questions, Your Honor.
All right, Mr. Diamond.
Yeah. What are the reasons why you didn't return the money, Ms. Williams?
The reason I didn't return them, sir, in December of 2020, I was notified by the Texas Child Support, and they told me that my case was no longer a court-ordered case. And they also told me that my son's father was always also notified. So how did I know he wasn't doing that on his own to rectify or compensate for what he wasn't doing for my child?
I'm sorry. So the point you're trying to make is that his contribution to your son growing up was insufficient, and this was maybe a way of trying to make things right?
Absolutely, sir. Child support only started in 2011. From 2011 before, I was doing that on my own. He chose when to take care of my child.
Okay.
So it sounds like it's an equitable argument that child support didn't go back far enough when it was initiated.
It did not. We have 9 years where I did this solely on my own. I mean,
Objection, non-responsive. This is
All right.
narrative.
All right, here's the deal, ma'am. Yeah, that's not going to fly. Again, this is kind of straightforward. Is there any other reason? I'm sorry, I can't go behind the order of 2011, ma'am. So is there any other reason that you're alleging that happened after 2011 that you should be granted some type of credit for, as far as the overpayment is concerned, ma'am?
absolutely, sir.
All right, what's the reason, ma'am?
Emotional, physical needs. I mean, he was never there for my child. It's more to take raising a child than finances.
Yes, ma'am.
I mean, the medical bills, the dental, and all of these things.
Okay, ma'am.
May I ask the witness a few more questions, Your Honor?
Go right ahead.
Are you in good health currently, Ms. Williams?
I am, sir.
And do you have other family members who have health issues?
I do, sir.
Are they close family members?
Sir, I do. We just lost an auntie just Saturday. Yes,
So I take it you help pay for some of the funeral costs?
I do. I have custody of my nephew as well. I lost my sister. I'm raising.
Where things heat up. The mother openly confirms she kept receiving payments after they should have stopped and chose not to return them. Her defense? Years of raising the child alone and emotional hardship. But the judge cuts through that argument, making it clear that personal feelings don't override legal obligations. When asked directly, she even admits it wouldn't be a hardship to repay the money, leaving her with no solid legal ground.
Him as well.
How old's your nephew?
He's 11.
Okay, here's what I'm getting at. You would have to show that it's a hardship for you to repay this $13,000. So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
Okay, here's the deal, ma'am. That you feel is not going to meet the legal standards for me to not order this, ma'am. Again, I've got to have some reason at law. I know you're not a lawyer, but you didn't retain counsel. I gave you the opportunity to do so, and I've got to hold you to the same standard. And right now, I'm not hearing anything that's going to get you to a legal standard of giving some type of forgiveness. I'm going to let the states continue to ask questions, but again, you can't. I've known people for years who they don't do it. They don't have a darn thing to do with their kids. All they do is pay the child support. And I've been saying for years, the only thing I can order is child support. I can order it based on what the law says I'm supposed to do, and I can't make somebody be a parent. That's not within my purview. So unless there's a legal reason, ma'am, that the money, and again, I know you're not a lawyer, but I got to hold you to that standard. Unless there's a legal reason for me not to order it, ma'am, then I'm probably having to look at orders. So is there a legal reason that you know of, ma'am?
It's not, sir.
Okay. All right, you may proceed, Mr. Diamond.
I don't know if there's much more I can add at this point, Your Honor.
All right, then.
A pass witness, sir.
Okay, anything on redirect, Mr. Starr?
No further questions, Your Honor.
All right, first off, I got to ask, obviously, we all sitting in here. I don't think, does the state have any witnesses that the state wishes to call at this time?
No, Your Honor.
All right, Ms. Williams, do you have any witnesses you wish to call at this time, ma'am?
No, Your Honor.
All right, at this time, I'll listen to closing arguments, and I'll start with you, Ms. Williams, again. Why shouldn't the court do what the court has been requested to do by the Christian firm in this matter? So, ma'am, thank you. This is your time to make a statement, another statement on the record, ma'am. Thank you.
No further comments, sir.
All right, Mr. Starr?
Yes, Your Honor. I just want to reiterate the law I stated in my opening remarks. 154.012 of the Family Code states that if you make a finding that someone has paid in excess of child support, not only can we bring suit to collect for the overage, but Section B states that if the obligee has not repaid the overage, the court shall order attorney's fees and court costs be paid in addition to the overage. You heard testimony from my client saying that there is an overage. The OAG confirms that there is an overage. He said my numbers were correct. And Mr. Guy has said he's not been paid back. And Ms. Williams has agreed with that assessment that there is an overage and she has not paid it back as well. The overage is $13,476.88. And attorney.
Now it all comes together. The father's attorney lays out a clean, undeniable case. Overpayment confirmed, no repayment made, and even the mother agrees on those facts. The judge doesn't waste time and signals that repayment is inevitable under the law. While the exact terms are still being finalized, the direction is clear. The legal system prioritizes accountability over personal justification. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
These fees before this hearing began are $5,808. That would make the total judgment, if my math is correct, $19,284.88. And we would just like to request that amount in our favor, Your Honor.
Okay. All right, folks. Again, this is kind of a straight out accounting one. What I'm going to go ahead and do, I'm looking at having to find, obviously based under the Texas Family Code, that the money that it appears to be uncontroverted, that the funds were paid to Ms. Williams, and they were in excess of the child support amount after the date of graduation and the child turned 18. So the court will reduce the judgment that unpaid amount. I am going to do a 48-hour return on this one, where I can actually see. I need to look up what if it was child support, I know what I would have to do as far as the repayments are concerned, but I'm not sure how this sets up. It's just a straight out judgment, how much I've got to order the repayments to be as far as the monthly amount is. There's still going to be judgment interest on this, and I've got to double check what the standard judgment interest is, because I know the Attorney General and this court has its own interest amount. So I'll have to double check that to see what that is, and that way I can give the make a ruling on what that repayment would be to try to do it over a certain amount of time, if that's also provided for under a normal civil action, and what that amount needs to be as far as covering the interest. And I got to see what the court has to do as far as attorney fees and getting that set up? Is that part of the judgment, or is that something separate? Mr. Starr, do you know off the top of your head, sir?
Off the top of my head, no, I'd have to look it up as well, Your Honor.
All right, here's what I'm going to do. I'm going to go ahead and reset this. Let's see, I think I already got a 1045 on Thursday, and I was going to use this Zoom code, but I'll either do it at 10:35 or 11:30 on Thursday to see what to get these amounts down pat and see what we're looking at. Okay, no, I do not have a 1045 on this Thursday at the general docket. So what I'm going to go ahead and do is move this Zoom code to that 1045 time slot, and everyone can check in without having to go in through the main docket on that day, which, with the 40 or 50 cases we have at that time. So anyway, folks, I'm looking at doing the judgment, but I got to figure out what the repayment amount is, and I've got to figure out what the interest is, and obviously that will be placed in your order, Mr. Starr. And if you can double check that and find that out, I'll allow you to present that to the court at the time, and I'll make the ruling as far as attorney fees going forward. So anyway,
Okay.
I'm taking this under advisement, and I'll see you, and I'm resetting this for Thursday, Wednesday, November the 30th at 10:45, same Zoom code to make the final rulings on everything in this matter. Is there anything else at this time, Mr. Starr?
I don't believe so, sir.
Anything else, Mr. Diamond?
No, Your Honor.
Anything else, Ms. Williams?
No, Your Honor.
All right, thank you all very much, and we're off the record. Everybody's free to go.
The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. Client's kind of stuck where he's overpaid child support for years, essentially.
I was not trying to be deceiving in any way.
It would be inequitable to charge the plaintiff an amount, and again, that would in essence have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the motion for the repayment. Screenly Court, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected